My name's Mike, as the label says, and I'm one of the senior partners at Corman and Company. And let me just see here if I can move. There we go. Okay. So my firm is a boutique real estate firm. We primarily handle real estate, whether it's residential transactions, commercial transactions. We do pre-construction work, primarily on the purchase end. We do handle wills and estates and corporate work on the side as well. So if you have to do, for example, a holding company, we can help you with that. Okay, so you wouldn't need to go to an expensive corporate lawyer to just prepare a simple holdco. We're happy to prepare one for you as part of any investment process. And importantly here, we can close deals anywhere in the province. So we do everything virtually, as I'm sure a lot of you do in your lines of work. And that means that we identify you virtually using a secure ID verification service called Treefort. It's pretty simple. You just take a selfie and then take a photo of your ID. It matches your face, make sure you're not, a Nigerian prince or something like that. Then we would sign the documents using DocuSign over video conference. So all of the information as well is also taken from you digitally. So I don't actually anticipate the need for having you into my office. So it's just an added convenience there for our clients. It's a very, very straightforward process. We make it pretty easy for you. All right, so here we go. Difficult tenants. This has certainly been in the news a lot past few years, and I've certainly seen I was going to say fair share. It's not fair share. I think it's an unfair share because people only come to me when they're having a big problem. So I think maybe I have an outsized view on how terrible this is. But anyway, you've of course heard these stories of tenants who are basically running a business, screwing over small-time landlords. So I had a client, sophisticated investor. He was a realtor as well, a very successful realtor, and he owned multiple investment properties. One of his properties, he decided he was going to sell it. It was a house in a nice area of Toronto. And it was rented, the whole house, to a tenant. Pretty good tenant. She'd always paid her rent on time. There were no real issues with her. And he went to the tenant before he listed the property and he said, hey, look, I'll level with you. I'm going to sell the place and I'd like to sell it vacant because I think it's going to be sold to probably a first-time buyer. It was the sort of house, it was like a starter home kind of house, and it was in that price bracket. It was about 1.5 million, the price. And so he anticipated that it would need to be vacant. To get the best price, he could also then stage the property for sale. Anyway, the tenant agrees. She says, no problem, I'll leave. So my client says, all right, well, I'm not going to give you an N12 eviction notice. What we'll do is we'll do a mutual agreement to terminate on the landlord and tenant boards N11 form. This is the landlord and the tenant signing off saying, we both agree to terminate the tenancy on the following criteria, okay? And so the tenant dictated her terms. She said, okay, I want 10 grand, I want this closing date, a few other little things that were pretty meaningless. And my guy said, yeah, no problem. That's pretty fair. I will sign off on this. And you're going to be gone by this date, no problem. So anyway, he decides after this, well, I'm not going to wait for her to leave. What I'm going to do is start the listing process right now. And I'm going to start the showings right now. I think that pissed her off a little bit. Anyway, he sold the property, okay, and he set his closing date for well after the tenant was supposed to leave. And everyone was expecting her to leave. Well, A couple of weeks before the closing date, the tenant says, oh, I didn't really understand what I was signing, and I'm no longer interested in moving out. So now the owner of the property, the landlord, is going to be in default of their agreement of purchase and sale because they said that they were going to give vacant possession to the buyer on the closing date. And no, they couldn't. Their tenant wasn't going to leave, okay? And of course, wouldn't you know, guess what the tenant wants? A lot more money. So now instead of $10,000, the tenant wants $80,000, and she'll still leave on time, okay? So she said, don't worry, give me 80 grand, I'll leave on time, okay? So obviously my client is like, hell no, that is extortion, I'm not gonna do it. And then he came to me and got the bad news that there's literally nothing he can do. The landlord and tenant board is about a year behind, okay? That means the N11 form he signed, fair and square with that tenant, is completely unenforceable. There's nothing he can do in the time frame he's got. Now, we were lucky. This particular buyer really, really wanted the house. They really wanted it. It was their dream first home. It was a young couple. They were moving from home, basically, from their parents' houses. So they didn't have to leave another property, all right? And so what happened is we were able to extend the deal by 3 or 4 months, somehow by some miracle. I don't know how the guy did it. The paralegal managed to get a hearing date, an urgent hearing date to deal with this. I don't know how he did it. Now, it was only a little bit before the closing date, so, even though we were able to have a hearing, and even though, of course, the landlord and tenant board said, well, tenant, you agreed on this, that's that, it was still gonna be another month and a half to get the sheriff. And the buyer then said, well, I'm not gonna extend again, sorry. So in the end, my guy ended up paying that tenant $50,000, ended up paying the buyer $20,000 to cover their, basically an increase in their mortgage payment, because this all happened at a time when rates were going up quite fast. Just, my predecessor, you saw that slide of the increase in rates right after the pandemic. That is when this happened, okay? Anyway, it was a disaster. And now my client is suing that tenant for extortion. And you can't normally do that. It was only a possibility in this particular circumstance because the tenant was the one who dictated the terms for the N11, and my client gave them everything they wanted. And then they came back and said, oh no, just kidding, I actually want more money. So anyway, I don't know how that's gonna go yet. I don't know if he's followed all the way through because, sure, you can sue a tenant, but are you gonna get any money? I don't know. So what do we learn from this? Well, one of the key things is don't offer vacant possession of a tenanted property unless you know that tenant is going to be out. And the only way you know that tenant is going to be out is if you get them out before you sign the deal, okay? And this now presents you with a business choice, right? You have to decide whether it's worth it to leave the tenant in the property and sell the property tenanted, or cover all the costs without any rent for a period of time so that you can then, of course, pretty up the space, do your staging, all that kind of stuff. What makes financial sense, right? And you're going to need to go through this with your realtor to figure out which makes most sense. But don't do what most of my clients do, and I say most because it is most, okay? Most of them ask the tenant if they're willing to leave, sign nothing with the tenant, list the property, sell it, then go to the tenant and say, hey, remember how you said you'd leave? Just sign this. And then the tenant says, screw you, I want 50 grand or whatever, okay? And 50, believe it or not, was nowhere close to the most that I've had demanded, okay? So this is a disaster. This is a disaster, And it is all because really the landlord-tenant board does not function on a normal time frame anymore. It's very, very delayed. And so as a landlord, you have to take that into account when you're making your choices. You have to know you have rights, you just can't enforce them. So work it into your choice to sell, okay? Oh yeah. Zoning. This is a fun one. We're not going to go into too many details here, but in general, I recommend figuring out the zoning before you sign your agreement, okay? Now, if you've got a condo, something like this, you're just buying an investment condo, don't worry about zoning. You don't have to, who cares? But if you're buying something like a fourplex, which is what my story is about, you need to check to see if fourplexes are actually legal before you sign the contract, okay? And so I had a client, a couple. They are, again, sophisticated. They have sophisticated jobs. They're very smart people. They own numerous investment properties, including multiple, triplexes, fourplexes, fiveplexes, these sorts of things. And they also just cannot pass over a smoking deal. They can't do it. They're like blinded by a good deal. They see a good price and they're like, my God, how can it not be the most awesome thing in the universe? So they bought a fourplex on Woodbine. And, they started doing some renovations to it. And then they thought, you know what? We can't get away with just little renovations. We're gonna have to do some more major work. So they went to the city to get some permits. And then the city says, what do you mean you're renovating a fourplex? That's a duplex. And also, by the way, did you know that house is zoned for duplex only? So anyway, the city, instead of giving them their permits to fix up the entire house as they had anticipated, they actually gave them a work order to remove 2 of the units in the property and evict 2 tenants. Now, thankfully, these clients had a good title insurance policy. I always recommend Chicago Title and Stewart Title. That's what my firm uses. I find them very, very easy to deal with, and they're very knowledgeable. But the title insurer stepped in, paid for all the costs to get rid of the extra units. And in fact, my client, I believe, used the money instead of to pay to get rid of the units. They actually went and fought the city, and I believe they got a committee of adjustment change to get 1 extra unit, but not 4. And all of this could have been avoided if they had looked at the zoning before they made their offer. And you can get that information online on the city's website. They have this wild map. And I say wild because it's like the internet from like 1995. I think that's probably the last time they actually updated it. And it's like pink and yellow and blue and what have you. And you sort of mouse over and it'll tell you, but you have to have a mouse. Like if you're trying with like a Mac, it won't work because you actually need 2 freaking buttons like to try and do this. Anyway, you can go there and you can find out what your house is zoned or what the property is that you want to buy, what it's zoned for. And so that would be very useful. Another thing that you can do is you can ask the seller to give you a representation and warranty about the zoning. So you can ask the seller, say, hey, I want you to represent and warrant to me as the buyer that this is a legal fourplex. You'll probably never get it, okay? And that leads me to another thing, which is the only way to figure this out, unless the property was built as a legal fourplex relatively recently, so you can dig out the permits from the city archives. The only way to figure out whether something is legal or not is to pay a specialist inspector to go into the property and make sure it complies with all the relevant building codes and make sure that it is, of course, zoned correctly. Because as soon as the zoning, you've got a fourplex and zoning says they won't allow anything more than 2, red flags. So anyway, keep this in mind it's very easy to check that zoning before you buy something like a fourplex. Or, if you do plan to buy a single family residence, for example, and then maybe split it up into multiple units, that's okay too. But again, just check the zoning. Because if the zoning doesn't allow for it, you've really got an uphill battle. Committee of Adjustments may agree, they may change the zoning just for you, but you've got to have a very, very special property. Otherwise, I would say, leave it alone, move on to the next property. Questions? They did, recently. This was before, it was just before, yeah, exactly. These people, oh yeah, they got screwed as soon as they had finished all of this. The city announced the change to fourplexes, yeah. Yes.
In that situation, the two tenants that have to be evicted or the one, do they have any legal standing against either the owner or the previous owner or the city enforcing eviction in the case of an illegal fourplex?
Yeah, so those tenants may have a right to go back to the landlord and say, hey, look, you didn't rent me a legal place. You need to help cover the rent because, to give an extreme example, let's say that a tenant was paying $800 a month and now the only place they can find in the same neighborhood is $1,500 a month. They'd have a claim against that landlord potentially for the differential. No. Yeah, you never want to try and sue government. Yeah. No. Yes, sir.
So, why would life insurance policy pay out to this if the landlord or the new owner should have known that it was not zoned property?
So, good question. And in this particular case, the owner just never checked. And personally, I think they kind of got lucky. They did have to sue the title insurer. And so the title insurer, they managed to get it one way or another because the title insurer basically insures over that if you buy a fourplex, it is a legal fourplex because they know how difficult it is to actually have certification of that, right? So they know that a lot of the buyers aren't going to be able to get certification. But they're also playing on the fact that most of the time they're legal in one way or another. Or even if they're not legal, it's not going to cost that much money to bring them up to legal standards. But yeah, the coverage is for a purchaser purchasing a multi-unit and then finding out one or more of the units are not legal afterwards. Even though in this particular case, they could have known that by checking the zoning. The title insurer doesn't require you to do that. Number of yeah, and you do have to get the multi-unit endorsement. Sorry, yes.
Maybe I'm misunderstanding, but you seem to be implying that it's difficult to confirm if you have legal.
That is precisely what I'm implying.
So for folks here that have done renovations and have legalized, can you just pull the permit? I mean, I understand it's something, I hope it's 3 years old, but for more recent?
For more recent, yes. So you can ask, and that's a good idea, okay? So if you see that the property you're buying has been recently renovated, ask the seller to give you the permits. It's, you can go off on your wild goose chase to the City of Toronto Archives and try to get your hands on the archived permits as well. That's never a fun exercise, but that is also a possibility. Sometimes they get your way and you don't have the signed authorization of the owner of the property. But yeah, you're right. So I do want to say here, it's very important that you get the multi-unit endorsement. And that is what the clients in this particular example had. They had a special endorsement on their policy that gave them the right to make a claim against the title insurer for something like one or more units not being legal. And I would say also, for context, this was a very old building. It was probably turned into a fourplex 50, 60, 70 years ago and was used that way for that entire period of time without any issue. All right. Okay. So, get the leases and the rent roll. And again, this is something you want to add into your agreement of purchase and sale. You want a representation and warranty from your seller that the leases are all up to date and a rent roll with the current lease amounts, okay? It's particularly important for residential tenants where there may be a lease that's 10 years old and the landlord has higgledy-piggledy gone and raised the rent, maybe some years, maybe not other years. So really, you can't just take the old lease that's 10 years old and figure out what the current rent is. It's also not a great idea to rely on the listing, okay? A listing is not part of your contract. It is called in contract law an invitation to treat, okay? It's suckering you in to make an offer. You are gonna have a hard time going back against the seller and saying, oh, well, you misrepresented the lease amounts in your MLS listing if you didn't put anything at all in your contract. You can still do it. It is a misrepresentation, but it's not as bad as a misrepresentation that's in your contract. Okay, so very easy. Ask the seller to put in a representation and warranty as to what the current rents are right in the contract. That way, if you figure out something's wrong before closing or even after closing, you can go back to the seller and you have a potential claim, okay? Also, I would recommend putting in something like a catch-all due diligence condition. This may not be possible in all contexts, of course, particularly residential contexts. Like I do appreciate when you're buying something like an investment condo or a single family home, the seller is not going to let you put in a due diligence condition, but it is standard procedure in a commercial context. So when you have multi-units, when you have commercial real estate particularly, you can have a due diligence condition that basically allows you to get out of the deal for any reason within a set period of time. And this is when you check your zoning. This is when you go over all the leases, you review them with your lawyer. You're going to be doing any other tests that you need to do on the land. For example, if developers purchase properties, they will often insist during the due diligence condition on doing things like environmental reports, soil engineering reports, things of this nature. And then if things don't turn out as they like, at the end of that condition, they can kill the deal, okay? So something to consider here. Also, a requirement on the seller to use best efforts to get the tenants to all sign tenant estoppel certificates. And these are pretty important because often lenders will insist on having these things prepared in order to fund on the mortgage. So if the bank says to you as the buyer, we need a tenant estoppel, and the contract does not require the seller to get those for you, the seller can say no. And then you as the buyer will be in default because the bank won't fund your mortgage, okay? So it's important to ask for those things. Again, if you have this great big due diligence condition, you could go to your bank, you could say, hey, are you gonna need tenant estoppels? And then during that condition, you can ask the seller, we need to add tenant estoppels to our list of due diligence things. If you don't sign the tenant estoppels, I'm walking, right? So it gives you leverage, that due diligence condition. And then there's some other little things here. You obviously want the tenant contact details so you can phone them yourself and make sure that the landlord's telling the truth. Hey, what do you pay in rent every month? That's handy. That's the next best thing to having everything actually put right into the agreement. Ask for the tenant details, their contact details. And then, of course, on closing, we want an assignment of rents and leases. It's standard practice for lawyers to do that. I don't imagine any lawyer you'd hire would miss that. We always do it at my office. It's not as important for a residential lease because the Residential Tenancies Act just takes over. But for commercial leases, yes, we want the assignment of rents and leases, which gives the new landlord official control over those leases. So, there we go, that's it. You are always welcome to get in touch with me. This is my email right here. It's very easy, mike@cormancompany.com. Email is usually best. I'll leave a few cards here. I've got to go right after this, so I will not be around for any handshaking. I'm a little under the weather. You don't want to shake my hand anyway. But I'll leave Andre with a few cards for myself and one of my partners, Akinyemi Asalu, who also does a lot of the commercial investor work at my office. Question? Yes. Mhm.
Fair trust agreement, is it a legal transaction or?
So you can have a bare trust agreement. That's okay. You cannot put a trust on title. Okay, so the Land Titles Act will not recognize a trust on title. So whoever the name is, whoever the owner is on title, the land registrar considers that person to be the actual owner of the land. Okay, doesn't mean you can't have one in the background. Okay, and lots of investors do it this way. Okay, but you can cause yourself financing issues because banks always ask the lawyer in the standard mortgage documents, instructions to the lawyer, whether there are any trusts. Are there any beneficial owners other than the people who are signing the contract? Because they don't want a beneficial owner coming back at them when the bank tries to power sell the property, saying, well, no, I never gave my permission to put a mortgage on this property. I signed this beneficial trust agreement, and here it says that the owner of the land isn't allowed to do anything without my express written consent, and I never gave it. Something like this, right? And so it's a big deal for banks. And again, you can do it, but it's kind of a smoke and mirrors kind of thing. It's not, if you own the property outright, okay, and there's no bank involved, of course you can do it, okay? But once you have a bank, if you don't tell the bank about it, you are committing mortgage fraud, like flat out. Yeah. Yes, sir.
Currently in the process of
Okay.
right, so a lot of
Yeah.
once we get a legal action, make the adjustments, and then
Mhm.
is it true that each side of the property, once officially severed, needs to be under two separate names, or the LLO has to be
Depends what they do. Depends what kind of severance they give you. Okay. But in general, you would want to separate them into two different names. You could, but it's often they'll give you 2 years to sell, something like that. Okay. So they say the severance holds for 2 years on these conditions. If you don't sell within that period of time, they can merge back together. But it's very detailed. Like there's a few different parts of the Planning Act that could apply here, but you've got to talk to the person who's doing this for you to see what is actually being gone for here. Okay, but in general, yeah, you want to separate them so that they don't merge, so that there's no risk of it. Yes, sir.
Yes, Mike. I was just wondering if there are legitimate ways to transfer, let's say, your ownership from, let's say, a sole proprietorship or a partnership to a holding company without triggering capital gains and also land transfer tax.
So, good question. Talk to your accountant, but some of my clients have done, Section 87 rollovers, okay? And this allows a sole proprietorship to move assets, including real estate, into a corporation. So it's a specific part of the tax code that basically lets small business owners incorporate as they grow for tax purposes. So yeah, talk to the accountant about that. Now, I can give you examples of, like I had one client who had purchased his primary residence in his corporate name. the corporation that he used to run his business. And he can't do it the other way. Okay, so when his accountant said, you're gonna miss out on your capital gains exemption for primary residence because this is owned by this corporate, it's a random corporation, it's not really just you, it does all kinds of other things. So I want you to move this back into the name, your personal name. The accountants can perform some, mathematical witchcraft in the background so that actual money doesn't really need to get paid for, the human to purchase the property back from the corporation. There'll be loans, for example. However, that doesn't excuse you from the land transfer tax in that situation. So again, I'm talking about a situation where you're going from a corporate owner to a human. There's more opportunity when you're going from a human to a corporation to avoid the tax. But Section 87 will work.
And that's just for capital gains or also for?
So it's going to be different in both cases, okay? But you know what? I honestly can't remember the last Section 87 rollover that I did. I can't remember whether he paid land transfer tax on or not. No, I'm sorry. In general, if there's no money paid, if there's no consideration paid, then there would be no land transfer tax. Land transfer tax ends up going when there is consideration, and consideration could be debt. Okay, so you just have to keep that one in mind too. If there's a debt going, and that's why you get nailed when you go from corporation to person, because there's a debt, there's a loan there instead for payment.
Thank you very much.
Yeah, and that's it. My time's up.
Thank you so much, Mike. Everyone.
Thank you.
Thank you, Mike. Appreciate it.